Welcome to the video presentation of an appeal for review of the judicial process for dismissal of charges in the Christian Methodist Episcopal Church by Pastor Dexter Harris to the annual conference 2024. May we pray. Jesus, we thank you now for the opportunity for justice to roll down into our annual conference. Allow truth to be the measure of the decisions we make. And Lord, we pray for your Spirit to guide and direct us in this judicial process. This we pray in the power of Jesus. Amen. I come to this delegation of this annual conference as an accused, charged, and censored minister. However, I come to make an appeal for charges to be dismissed in two complaints. Complaint 1 and 2 will be shared during this process. For the sake of this video, I ask all of those who are delegates of the annual conference to use your insider information. This video has been redacted for anonymity, meaning there are no identifying names or anything here that would try to identify where or who these charges apply to. So please know also this is an educational video. You may stop the video to read documentation because documentation will not be read in full. For your full understanding, please pause the video to read the documentation when encouraged. Thank you for your time as we go for this opportunity to learn of the justice process or the judicial process in the Christian Methodist Episcopal Church. The Book of Discipline of the Christian Methodist Episcopal Church, revised 2022, shall be, and published by the CME Publishing House, shall be our course outline for this appeal. I ask that you would have pencil, pad in hand to take notes so that you may have questions or questions for you to go back and redirect in the video. I come today to make an appeal to this body that we would look to chapter 44 of the Book of Discipline, chapter 44 entitled The Judicial Administration of the Christian Methodist Episcopal Church. I ask those who are here now to take the time to pause the video and read this entire chapter as I am now scrolling. And this video will only cover up to paragraph 803.5 on your screen in the left panel up to the appeals process. Once again, I ask for all those who shall make a decision on this motion for dismissal of charges The Book of Discipline gives a bishop a right to suspend a preacher in full connection when he sees that there may be somebody might be in harm's way. In this case, this course was taken, and our bishop will be the one who would tell all of us about the course he took in this case and why. However, I'm not here for that. I'm here to talk about the process in which I have been through as an accused preacher in full connection. Please also be mindful on page 182 on your left panel. Please, ma'am and sir, note that this process applies to all members of the Christian Methodist Episcopal Church. Just so happened in this case, there happens to be a preacher in full connection. As we start our examination, practices subject to disciplinary action at the top of page 183, we will get to those practices in which I have been accused of practicing. Let's start with the judicial process. The judicial process is the justice department of our church whenever there is an accusation. And you can see in paragraph 803, accusations are dealt with. Please, ma'am and sir, refer to the full text. However, I will only be pointing out the matters in which I believe the judicial process was violated or was not kept to in order for charges to be able to be made in the complaint 1 or complaint 2. The Book of Discipline suggests this judicial process in order that truth may come to light whenever there is accusations. Section 1 of paragraph 803, as we would have here, it gives us a beginning course. Please read it for your entirety. However, we must understand that even though a bishop has the power to make a unilateral decision to suspend a preacher, this process suggests that we have a process so that we can get to the clear-cut truth in order that a unilateral choice will not have irreparable consequences. The choice not to use this judicial process found here, beginning on page 183 of chapter 44 of the Book of Discipline, it is of concern because it helps to get to the bottom of a matter. Section 1 of this paragraph calls for the proper official to make discreet inquiry of the matter. Let me say to this annual conference committee, there was discreet inquiry made on complaint 1 and complaint 2 by the proper official. And that is where the process stopped here. After discreet inquiry, then suspension came. But this process outlined in section 1 of paragraph 803 was not had. Discreet inquiry was had. The next step is that the report of the same is supposed to be generated by the proper official that there is some basis in fact of accusation. I, Dexter Harris, never received a report of any basis in fact of any accusation. I received a letter of suspension. As you can see here in the paragraph 803 section 1, that report is to be shared with the accused and private reproof is to be given. Private reproof never was given. Even though it might have been stated as given, there is no private reproof. I've never received private reproof. In section 2 of the same paragraph 803, it calls for a warning to be given to the accused by the presiding bishop, presiding elder, and 3 other ministers. And now let me refer to the Book of Discipline here. This section says that there is supposed to be a report generated Warning be given by the presiding bishop, presiding elder, and 3 other ministers. Let me advance to the next part of section 2. There it is, and 3 other ministers. In this case, for the in the annual conference, a minister in the annual conference is supposed to be done. Warned in this process, I once again ask for your dismissal. I never was warned by anybody, any ministers. I only received a suspension letter to start this judicial process off. And an example of a suspension letter for anybody who ever goes through this process, I do have an example that has been redacted. All of these documents are redacted for concealment of identity of parties. This appeal is not to be a mess. This appeal is to get to truth. And so here is please read it in its entirety. As I scroll, you may want to pause. That is the entirety. This was the first step in the judicial process, in this case, a suspension letter. It wasn't a warning, as section 2 of paragraph 803 suggests. I asked this annual conference to dismiss. This is not just my beck and call, but a beck and call for us all who may carry out a judicial process, because it applies at every level of the church. And if we are not willing to take these processes serious, and we're willing to make unilateral decisions, then okay, that's fine. The church can make that decision. However, I think the Book of Discipline helps us to see and to get to a process that can be, one, fair for all parties to get to the truth, so we may know justice. If any one part of this judicial process is overlooked, then we must dismiss. If any one part of this judicial process is not legit, I would dare say we must dismiss. I would dare say we must dismiss. And keep in mind, in this case, there are only 2 complaints. However, the Book of Discipline tells us, as we see in section 3 of paragraph 803, which is now on your screen. You will read that in full. Section 3 says if there is a third offense in writing, there is not a third offense in writing in this case, but if there is a third offense in writing, has been given to the accused a signed copy of the third complaint by an accuser, then the committee of investigation is to be appointed. Once again, section 3 was not applied in this case. Let me continue. Section 4 of paragraph 803, which is now being highlighted on your screen. Section 4 says all accusations of offenses over a year ought to be dismissed. In this case, complaint 1, accusations is over a year, and we'll get to the complaints once we get to the committee of investigation part. I did suggest to the tribunal for this section to be applied for dismissal for complaint 1, and it was denied because I became power of attorney of the said victim over a year. And it goes on to say in section 5, and highlighted on your screen, section 5 does give the proper official the authority to appoint a paragraph 803.1 committee of investigation immediately. And this section 5 was the first step in this case, because first came the suspension letter, then came the committee of investigation process, And if anybody goes through charges, you do want to reply at every step. I did send a reply letter for the suspension letter you have read earlier. And now I ask each delegate to do the same to make sure you've read the suspension letter. And this is my reply, because in any judicial process, if anybody brings a claim against you, you must be able to reply in writing. And here is my written reply to the suspension. Once again, these documents have been redacted, so nobody's identity is made but mine. Please read that in its entirety. You never know, one day you may have to reply to a letter of suspension. To my fellow delegates, please always remember to pause and read the discipline, and as I show a exhibit, if you will, take in consideration. That is a good point to make notes for yourself. Because as we move into this next part concerning the Committee of Investigation, I ask that you take notes, because this is the part where we give most ground for dismissal. The Committee of Investigation's duties, as you have already probably read, are listed. And we would want to make sure that every member of our church who may be accused has the opportunity for the justice process to take place. Here is where most of truth can be garnered. However, if this process is not followed, it will be hard to get the truth of the matter. On December 19th, I was communicated a letter concerning a Committee of Investigation meeting. Please, ma'am and sir, take a look at this exhibit of the notice of Committee of Investigation meeting, as well as the reply of the proper official to my reply to the letter of suspension. As you will read, you will find all of the logistics about the Committee of Investigation. Here I also enter in the only written complaints I have in my possession as the accused that are now on your screen. You see complaint 1, complaint 2. Please take the time at this time to pause and read these complaints in full. And also read the reply of the proper official to my reply of the letter of suspension. Once again, here you see the accusations and the complaints, and you do not see any names attached. As you will see here, it says, as I highlight here, it says the complaints are below without person's name until we are in the meeting on Thursday, which is December 24th. Well, written complaints supposed to have the name of the accusers. Here we see that is not the case. And so to this annual conference, I would ask you, and there is no written complaints with any accused name on any process or any documents I've seen. And I'm asking you all to dismiss these charges, because these complaints do not have proper accusers attached by name to give the accused the opportunity to face the accuser. And so I'm asking you, ma'am and sir, to please consider dismissal based on that the written complaint does not have any accuser's name on it. And for me to name a name of an accuser without it being written would be for me to commit hearsay. I'm not here to commit hearsay. I would just ask for this delegation to ask the Committee of Investigation for any document or record that they have with the name of the accused on it. I don't have those documents. Never was turned over to me. I heard a name or two, but I've never seen a written name, and I've definitely never faced those persons, as I will point out. As you can see, in paragraph under the Committee of Investigation, in paragraph as 803, paragraph 803.1, subsection 1C, and I will highlight it for your attention. It says that the presumption of innocence could not, I'm saying that presumption of innocence should be started. I ask this delegation to consider going back in your memory to Saturday, December 2nd, where there was a Zoom meeting and where the proper official made a statement during the financial report of a certain church and made mention that a certain pastor had did something he had no business. Innocence went out the door on December 2nd, 2023, during the winter accounting meeting, when the proper official made a judgment that the accused had did something wrong which he had no business. That right there threw out the presumption of innocence for anybody on the Committee of Investigation. It threw out the presumption of innocence for anybody who shall serve on the tribunal. Those who were in the winter accounting meeting, you are witness to this statement. For that, I ask you all to consider dismissing these charges. There is no presumption of innocence, and you will see the effect of this as we continue, because I believe that statement biased the Committee of Investigation, biased the tribunal. I'm just praying that that statement has not biased this annual conference delegation. That statement also was made again in the spring meeting. Spring meeting, the proper official made the same statement, that there was something done to cause a certain church not to be able to pay their obligation. And once again, that statement came before the tribunal, which caused presumption of innocence to be gone out for the tribunal also. As we continue, as we look at paragraph 803.1, subsection 1D, it's on your screen highlighted. Proof has not been submitted by the accusers in complaint 1 or complaint 2, nor has proof or a written accusation by the accusers been submitted to the accused. The Committee of Investigation nor the tribunal can produce any written accusations by the accused. And if that process, that's not legit, so I pray for you all to consider voting to dismiss. If the process is not legit, then I ask you to dismiss. As we move on in the book of discipline, as to this case, I now highlight for you another duty and responsibility of the committee to the accused. The committee never granted the accused the right to face the accusers in this case. I am still asking the question, who is the person that I heard to be an accuser for complaint 1? There was never an opportunity for me to confront my accusers. This opportunity was never provided. So if there is no evidence of me or the accuser facing the accused, that is a reason to call that this judicial process was not legitimate in the investigation. Therefore, it's a dismissal of charges. And I ask, as questions and answer period may come, that the delegation asks the question, where is the proof that the accused was granted the opportunity to confront the accusers? I've never had that opportunity. I never had the opportunity. And in a judicial process, no matter where you are in a judicial court or judicial process, to be able to face your accuser is paramount in any judicial process to be able to reach justice. To be able to reach justice. It wasn't done in this case. I ask you to dismiss. For both complaint 1 and complaint 2, this was not done. If it wasn't done, that means this judicial process is not legit. And I ask you to dismiss. As it says in paragraph 803.1, subsection 3. I'll just highlight the number and you can read the text that follows. That is on your screen. The committee did not contact one witness I gave them to contact in support of the evidence I submitted. The committee did not even contact the so-called victim and document that contact. There was hearsay accusations of a contact, but there is no documented contact with the said victim or any witness that was submitted. 4 witnesses were submitted to the committee, and none of those witnesses were contacted by the committee to verify what I said, the documents that I provided. I haven't gotten one document from the committee, from the accused, and so I ask you to consider. Dismissing these charges. Paragraph 803.1, section 6. Never was followed in this process, which was highlighted on your screen for you to read. The committee grounds to break bill of charges and accusations as written. The committee never gave written accusations from the accusers. The presiding official told me that the names of the accusers were not placed on any written documents in order to protect the identity of the accusers. The Committee of Investigation chose to draft charges, and the bill of charges came. As I've stated on plenty of occasions, how can you draft charges when the process doesn't seem to have followed the way it should have followed? Tribunal was called. However, I want you to know a bill of charges was only brought after the Committee of Investigation had two interactions with the accused. The first interaction is when I handed over several documents for both complaints 1 and complaint 2. Emailed them the following day after we had the December 21st meeting. The only interaction I had with the committee is this document you see on your screen, asking for certain information concerning complaint 2 only. There's no information exchanged by complaint 1 on complaint 2. Then, after such communication, I was notified that the committee had made their decision, and the decision was to bring charges. And so, we went to tribunal. As I tried to explain to the tribunal the mitigating circumstances that the Committee of Investigation did not allow me to face my accusers. I never got any documentation to examine. None of my witnesses were ever called, and they encouraged me to move on. And this is just for the sake of learning. You can see the tribunal process here. Please, ma'am and sir, pay attention to this. You never know, one day it may be you. As I begin the tribunal, I pleaded mitigating circumstances to talk about how there can be no charges if there is no judicial process in the investigation. There was no investigation, so how can there be charges? The steps for an investigation were not followed. I was encouraged to push on by the chairperson of the tribunal. Said he didn't know all of that was supposed to be in the investigation. He didn't know what I was talking about, asked me to push on. I don't know if that's the way a tribunal was supposed to go. However, the Book of Discipline encourages the tribunal to give the accused certain rights. And I'm pointing out here in paragraph 803.3, subsection 3B, which is on your screen. This process never took place. This process never took place. This right was curtailed as I began to share. I was told to move on. I don't know what move on is. I'm asking you all here to consider that the accused was not given the right to make oral or written presentation in full, because parts of my presentation I was encouraged to move from. So I ask you in this delegation to please consider asking the tribunal for the record. They have the record. They have a audio and transcript of the tribunal. What I'm saying can be verified in those records. Also, Lastly, paragraph 803.3, subsection 3D. Was followed. And lastly, bill of charges was brought, and it says that it was done appropriately, and as the bishop had saw as appropriate, and I just asked for you all to look at the decision for educational purposes. The bill of charges. Let me just make that a little clearer for everybody as we close this video. Here's the letter of the bill of charges sent to the accused. And so you see on your screen the letter. Enclosed in that, you can read the full. And I just asked this body to also examine this comparison. According to paragraph 803.1, section 6, the appropriateness of the bill of charges to the complaint. Complaint 1 says, the grandniece of said Allen, a member of said church, registered a verbal complaint followed with documentation that Reverend Dexter is responsible for her aunt being evicted from her home, as well as claiming power of attorney of Allen's personal affairs. She also claims that Reverend Harris has started a business in Allen's name. And I would just show the following. Well, let me clean that up for you guys. Let's see, it's a little wild. Sorry, I didn't know the page was cut off at the end. Excuse me. This comparison is for those who ever have complaints brought against you and what bill of charges shall be written. This is for complaint 1. It's for learning purposes. Paragraph 803.1, section 6 says the charges and the censorship is supposed to be appropriate to the complaint. I don't think this is appropriate to the complaint when you see complaint 1's charges. I would ask you to consider that for complaint 1, the accused had legitimate power of attorney of said client Allen. I like to call her client Allen. This is a durable power of attorney that was granted to me. Let me show you why I got that durable power of attorney. Because on July 20th, 2022, a letter came in the mail to said Allen, and my services were sought so that I may stop an eviction, not to cause an eviction, as the complaint says. This was an eviction caused by the owner. I came in to represent the interest. Hold on, let me clean that up because I see now. I'm sorry. I see that we still have issues with the whole document being on the page. There we go. And I'm sorry once again to waste your time. But let me make it justifiable, easy for everybody to read. And so this durable power of attorney was secured 2 weeks after I was notified of this notice. So this is what causes eviction when a owner wants to go up almost 300% inflation on rent. And here is an example of this inflation. You can read it here. Complaint 1 says, I caused the eviction. No, the eviction was caused by the owner wanting to go up from $500 to $1,400, which is evidenced here. in this text communication from the property manager to the accused, which I am representing the interest of said Allen in this case. Also, it is accused that I caused an eviction, or I caused said Allen to be able to relocate with $3,000 relocation funds from this inflated residential rent. And here is documentation, full documentation, that on Thursday, December 7th, $1,500 was paid to a new landlord for said Allen, client Allen. And on Tuesday, December 5th, 2023, another $1,500 was paid to the new landlord for said one Allen. There's evidence I did not cause an eviction. However, I stayed off an eviction for over a year and caused said Allen to be able to relocate with relocation funds. Let's move to complaint 2 as we close. Complaint 2 says an officer of said church has a written complaint followed with documentation that Reverend Harris has transacted business on behalf of said church without authority. She accuses Reverend Harris of filing paperwork to satisfy the church's mortgage, which has not been satisfied. The accusation also claimed that Harris is the reason for the church not being led to being led to additional debt and legal. Please just read that, but I want to focus on this accusation, which it says mortgage has not been satisfied. That accusation is documented to be untrue. And once again, I ask the delegation to consider these documents. As we move forward, here is a officially recorded, but although redacted, officially recorded satisfaction of a mortgage of said church. And I will scroll through the letter, even though it's heavily redacted, for this is a certified copy that was obtained after the charges was given by the Committee of Investigation. And this shows an actual satisfaction in a certain county in a certain state of a certain mortgage. So please, ma'am and sir, consider stopping and reading this document as evidence to show that satisfaction of this particular mortgage was recorded and still is in said county. On those terms I've submitted, please, ma'am and sir, consider dismissing these charges. The book of discipline was not followed. The judicial process was not legit. I pray that you dismiss. I put in a motion that the charges of complaint 1 and complaint 2 of Reverend Dexter Lamar Harris be dismissed at this time.